All right, good evening, everyone. Welcome to the Judicial Proceedings Committee. We are on voting list number 5. Today's Thursday, February 13th, 2025. We're going to start off with Senate Bill 81.
Senate Bill 381.
No, 81.
81.
81. It is 81.
Oh, right. So Senate Bill 81, this is interference with a public safety answering point. This alters the existing statute on computer misuse and adds 2 new prohibitions. One is a violation of the existing statute with the intent to interrupt or impair the function of a public safety answering point. The second is if the perpetrator actually does interfere or interrupt the functioning. There is one amendment in your voting packet, and that amendment provides, it strikes the prohibition against committing an act prohibited under the existing law that in fact does interrupt or impair the functioning of the public safety answering point, and instead just retains the prohibition that of a violation with the intent to do that. Makes corresponding changes to the penalties.
There's been a motion to move the amendment. It's been moved. Now the bill's before you as amended. Is there further discussion? There's been a motion for a favorable. It's been seconded. As was pointed out by my friend, we are going to leave it open for discussion. Any more discussion? All right. Okay. Procedurally, I appreciate you too. Thank you. All right. So the motion for favorable, is everyone okay being recorded in the affirmative? Yes. Okay. Senate Bill 81 with amendment passes unanimously. We'll now move on to Senate Bill 44. That's Josh.
Senate Bill 44 specifies that a person charged with reckless or negligent driving that contributes to an accident resulting in the death of another must appear in court and may not prepay the fine.
There's been a motion for a favorable. There's been a second. Further discussion? All right. Is everyone okay being recorded in the affirmative? Yes. Senate Bill 44 passes unanimously. Okay. We're going to hold Senate Bill 193, and we're going to move on to Senate Bill 326. I've got an amendment for this one. Hold on one second. Before you get, I have an amendment. Senate Bill 326. Let's go ahead and read Jamie, and then I have an amendment.
Sure. Senate Bill 326 prohibits, with certain exceptions, the disclosure of the contents of any written or oral communication regarding a peer support interaction by a peer support specialist or peer support program participant. The peer support specialist must inform the program participants in writing of the confidentiality provisions that apply from the bill. This is applies to law enforcement agency peer support programs. Essentially, it mirrors provisions that are in law with respect to firefighter peer support programs.
Right. As I have a sponsor amendment, I'd like to join on. Is anyone? Senator Sidnor, West, Folden, Muse, James, Henson, Love, McKay. Everyone's on. Everyone's on.
Everyone but Nick, Charles.
All right.
You want it?
The whole committee's on. All right. Sponsor amendment as the entire committee as a sponsor. Now the bill's before you as amended. Motions for a favorable.
Second.
Second. Is everyone okay being recorded in the affirmative? All right. Senate Bill 326 with amendment passes unanimously. We'll now move on to Senate Bill 381.
Senate Bill 381 generally prohibits an agency that operates an automated enforcement program from accessing or using a recorded image or associated data without a warrant, subpoena, or court order unless the access or use is for an appropriate traffic enforcement purpose. The bill also alters and establishes new provisions regarding the requirements for the use, processing, and disposal of recorded images and associated data. There is an amendment in your packet, which is number 413321. The amendment makes a couple changes. First of all, it alters the process by which a law enforcement agency may access and use the images and associated data that it already has in its possession. Essentially, instead of requiring a court order, it requires that the agency essentially have a written request documenting the legitimate law enforcement purpose for which the image or associated data is being sought. And the custodian of the records is required to keep a written record of those requests and whether they're granted or not. The second change that is made by the amendment is that it alters the time frame which an agency is allowed to retain images of allowed to retain images and associated data regarding violations. So under the bill, it would have been 6 months or until any court action related to the violation was resolved. So under the amendment, it's that they may retain the images and data for 1 year following the conclusion of any criminal investigation or the exhaustion of all the avenues of adjudication for the violation.
Just ask for brief explanation. So Senator Love, you were, okay, Simpatico? Senator Sidnor.
Thank you. This is a question for council. If this bill passes, is the breadth of the bill enough to capture any, let's say we were to pass some of these other automated, maybe the stop sign or something like that. Would the breadth of this be enough to capture data from any other recording devices that we might adopt later this session?
No, so it does specifically enumerate the programs for which it applies. So I would, if you want to do that.
Thank you.
Thank you. On page 5, line 10, lines 10 and 11, any other, on the amended version, any other automated traffic enforcement system authorized under state law.
Correct. Yep. Sponsor is correct. I'm wrong. Thank you to the sponsor.
Sorry.
All right, so let's move the amendment. It's been seconded. Okay, second. Now the bill's before you as amended. Is there further discussion? Senator Folden would like to be added as a Me too. I almost want this to go to the floor.
The senator did offer me the opportunity to have input into making this
A better bill.
without warrants, and I think it's a really solid process.
Wonderful day.
I'd like to be part of it.
All right.
Build on the big board in the
It's Senator Folden and Love. Love and Folden. Sidnor wants to be on it.
Here, love some folks.
Wheezy, I'm coming. I'm coming, Wheezy.
Easy.
What is that?
You didn't mix up 2 shows.
And Sidnor on the bill. Went in on there. All right. So now, Senator McKay.
Did any of these amendments address the concerns from the Chiefs Association, all their concerns? It took care of it all? Okay, then I'll be a co-sponsor.
All of them did. They did not want to have to get a subpoena warrant or court order for data that they own, so that does. They also wanted 1 year, so that does.
Forgive my ignorance, was the process before the bill that they could access the information without a warrant, or is the amendment to the bill changing what was existing law?
Thank you. There was no process beforehand. They could access it for whatever they wanted, whenever they wanted, however they wanted, and anybody else could as well. There are no statewide standards whatsoever.
Oh, wow.
It was left up to agency procedural guidelines.
Yeah.
Okay.
The county required a warrant, which wasn't necessary.
Subpoena.
They wanted to be like really secure.
Sure.
So we just wanted to have a tracking pattern that was consistent across all fields, that there would be a request, there would be a response to that request, and then that request had to specifically annotate why or the justification for that request. So we're not trying to slow down the process of crime solving, but we want to make sure that it's properly documented and the request is for a bona fide law enforcement purpose.
With respect to the data that they already own. If
Correct.
somebody else holds that data, then they need to get a subpoena, warrant, or court order for it.
Okay.
Does
Do
that
we
make
know
sense?
what Anne Arundel County was doing? What were they doing?
I don't think theirs is a procedural thing. It just standardizes it.
Did it require a warrant like Montgomery County? Do you know offhand?
That was their
Was the
choice.
only one? Okay. Thank you. Thank you all. Thank you, Mr. Chair.
All right, second, is everyone okay being recorded in the affirmative? Excellent. Senate Bill 381 with amendments passes unanimously. We'll now move on to Senate Bill 443.
Senate Bill 443 reclassifies the prohibition against transporting a regulated firearm into the state for the purpose of unlawfully selling or trafficking the firearm from a misdemeanor into a felony. There is one amendment in your voting packet, and that amendment alters the applicable statute of limitations for firearms trafficking under 5140 of the public safety article from a 3-year period after the offense was committed to prosecution can be brought at any time because it's being turned into a felony.
So you can explain, like, so felonies generally don't have, statute of limitation, but you felt, just kind of a profile, just explain, can you explain that process that way?
As a general rule, in Maryland, misdemeanors have a 1-year statute of limitations, and felonies have no statute of limitations. There are exceptions in the code that's found generally in the Courts and Judicial Proceedings article, and that's actually what the amendment addresses. In this instance, at some point, the General Assembly had determined that a 1-year statute of limitations for a violation of the firearms trafficking law should be longer. So it turned it into a 3-year statute of limitations. This bumps it out to conform with all other felonies or most other felonies to be a unlimited statute of limitations.
Thank you, Mr. Chair. So briefly, and I'm going to apologize because I know we spoke on this the other day, and I didn't have my notes with me. Was there a discussion? Did we have a discussion to that consideration for that each firearm was a separate felony, or was it? So you follow?
Is that the unit of prosecution would be each firearm, because the specific prohibition is actually
because they're serialized, they're each independently their own weapon, right?
Well,
I just wanted to,
no, it wouldn't have anything really to do with the serialization, just whether each thing meets the definition of a regulated firearm.
Okay.
But the specific language is that a dealer or other person may not transport a regulated
oh
firearm.
yeah, true, good. Okay.
So yeah, I think it
all
would
I
be
need.
each gun.
Perfect, thank you.
It's particularly relevant for ghost guns. Second, all right, is the motion seconded, and we've got the bills before you. Senator Henson, yep, Senator Henson has a question. Yes, I'm sorry, I'm sorry.
It's on the bill. Is this the
Yes,
appropriate
absolutely,
time?
yes.
Did the penalty not change, just the classification went felony from misdemeanor to felony? Okay, understood. Thank you, Mr. Chair.
Oh, let's say there's Senator James, Senator Folden wants to hop on. Senator West wants to hop on. Senator Sidnor wants to hop on. Yes.
Just one question, Bill. I see the
Thank you, Q.
transporting with the intent. Is there any way that someone who just happens to have a gun, maybe they are using it for target practice, or they're going to if they cross the line, is there any way that they can be caught up in this traffic?
Counsel, but that doesn't qualify as a definition of trafficking or selling
I
it.
see what the definition
Yeah.
of that is.
But
But one's interpretation of it, or police's interpretation, judge's interpretations anyway?
Sure.
It's never been, I can just tell you, it's never been an issue. I mean, trafficking is pretty clearly defined.
So it's not just one gun that had to have one?
No, it's,
Okay.
yeah.
Yeah, I thought it was kind of broad, but okay, fine, thank you.
Now the bills before you, sorry.
Just to confirm, James, Bolden, West, and Signor, co-sponsors.
McKay.
I'm sorry, what? Wald Striker. Yep. Muse wants one. Anybody else? Love, got it.
All right.
Jill Carver would be proud of us.
Okay.
I don't know.
Now the bills before you as amended. Motions for favorable. Second. Okay. Is everyone okay being recorded in the affirmative? Okay, that's fine. Senate Bill 443 with amendments passes unanimously. We'll now move on to Senate Bill 444.
Okay, Senate Bill 444. As drafted, Senate Bill 444 requires a person or entity operating a gun buyback program to destroy a firearm, including every component and part attached to the firearm that is traded in at a gun buyback program. The destruction must make the firearm and every component and part attached to the firearm permanently inoperable and irreparable. A person or entity may contract with a law enforcement agency, an organization, or a business to satisfy the firearm destruction requirement. A person who violates is subject to a maximum fine of $10,000 per violation. If the violator is a licensed firearms dealer, in addition to the fine, the Secretary of State Police must revoke the dealer's license. There's one amendment in your voting packet. This actually conforms the bill to language that had come out of the Senate last year that addressed some concerns that had been raised by law enforcement. Just to sort of run down the changes quickly, essentially would apply the provisions of the bill to federal firearms licensee or a law enforcement agency. Those would be the only two entities that could conduct a gun buyback program. It still requires destruction, and it does include an exception for something that's determined to be evidence. I just want to double check that. Right. It does not apply to a firearm if it's determined that the firearm is stolen or is evidence of a crime. It also includes a specific prohibition that says that somebody who is not an FFL or a law enforcement agency isn't allowed to do this. They would be subject to a misdemeanor $10,000 penalty. Right. The information that was given to the committee was that generally it's only law enforcement agencies that are running these. It also has a provision that says nothing in the subtitle may be interpreted as an exception to any other requirement or restriction under state or federal law relating to the purchase, rental, loan, or transfer of a firearm. So every other part of state or federal law is still in effect.
Here's my only concern, because I understand the intent of this in the buyback program. However, when I read on page 2, line 28, and then on to page 3, where it gives the definition of a buyback program, it says that a program that is operated by a public or private person or entity, which we said was an FFL or law enforcement, that allows firearm owners to voluntarily trade in their firearms for compensation. So I can tell you that that language, because of how loosely it's written, that if I want to go in and I want to trade in, I have an older pistol and I want to go trade it in towards a new pistol. And if I trade it in voluntarily and they compensate me for it, by the way this is written that way, because it doesn't specifically say unless a trade-in, then it would be subject to this.
So thank you, Senator Fulton. So on, if I could direct you to page 2 of the reprint for, and I'll just read the amendment number. It's 943128/1. So going down to page 2, line 28, it does actually change the definition of a gun buyback program. It would mean a program that's operated by a federal firearms licensee or a law enforcement agency that, one, allows
Well,
fire.
I don't have that.
I'm looking for my.
I don't have that.
Where is that?
Like, that's not what mine says.
Is this it?
Okay, Jamie, go ahead.
Sure. So it's a program that is operated by an FFL or a law enforcement agency that, one, allows firearm owners to voluntarily surrender firearms. Two, is operated either explicitly or impliedly for the purpose of reducing the number of firearms in the community. And three, advertises that firearms that are surrendered to the program will be destroyed or made permanently inoperable.
That satisfied that. What I had was, yeah, that satisfies both of them. So thank you.
So I'd like to move the amendment, and then we can, is that okay? Second, all right. So now the bill's before you as amended. Further discussion? Motions for favorable, it's been seconded. Do you want to do roll call, or is, do we? Okay, yeah. Okay, so Senator Folden and McKay are down. All right, everyone else is up. Okay. Get down, get down. All right. So Senate Bill 444 passes with the amendment. Was it 9-1? 9-2, sorry. 9-2. All right. Now move on to Senate Bill 455.
Senate Bill 455 expands the entities that are authorized to apply for the appointment of special police officers to include a person that holds a valid license as a security guard agency in order to protect property owned or leased by its clients.
I'll jump on it, is it? Okay. All right, so I'll jump on as an amendment for a sponsor, so just, I don't know. Does anyone else want to jump on? Senate Bill 455. West, Folden, okay.
And Smith.
And Smith. All right, now the bill's before you as amended. Senate, motions for favorable with the amendment? Seconded, is everyone okay with being recorded in the affirmative? So Senate Bill 455 passes with the amendment unanimously. We'll now go on to Senate Bill 513.
Senate Bill 513 alters a statutory provision in regard to a notice that a local government has to provide when it intends to execute and record a restrictive covenant modification to an unlawfully restrictive covenant. Currently, that notice has to be given by first-class mail. This bill expands the permissible methods to include that notice can be published once per week for 4 successive weeks in one or more newspapers of general circulation in the county or municipality where the property is located, posted on the door of a courthouse or on a bulletin board in the immediate vicinity of the door of the courthouse of the county or municipality where the property is located, or posted on the official website of the county or municipality where the property is located. There is an amendment in your packet that takes these 4 options down to 2. They can use the newspaper method or the website method.
This was done to assuage the concerns that they had, because they had one amendment, they wanted to offer just all of it, and that's defeats the purpose of the bill. And then they called in, and they said, hey, there's got to be some sort of a a regular place where the public should know to look. So if you have too many, it kind of defeats the purpose. So the website or in the local newspaper, but it doesn't have to be both. So I think it satisfies their concerns. They're off of it now, so. If the sponsor's okay with that. All right, I'd like to move the amendment. Second. Now the bill's before you as amended. Actually, so there's another amendment. Actually, I want to be on this too. Senator Muse, Senator Love, Senator Smith, Senator Wallstreicher. Sidner, do you want? It's to make it easier to get the restrictive. So Senator Sidner's on. Charles, you want to? Senator.
Senator Charles, do you want? All right, so I have Muse, Love, Smith, Waldstreicher, Sidnor, and Charles. Anybody else? Good to go?
All right. Motions for favorable with the amendments. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 513 passes unanimously with the amendments. Now go on to Senate Bill 533.
Senate Bill 533 alters the time limit for filing administrative charges for police discipline matters. It does this in a couple of different ways. First, it establishes that for an incident involving a member of the public and a police officer, the process of review by the investigating unit through disposition by the Administrative Charging Committee must be completed within 1 year and 1 day after the date that the appropriate official employed by the law enforcement agency became aware of the incident. Second, it requires that a law enforcement agency file any administrative charges arising out of an investigation of alleged police officer misconduct that is not required to be reviewed by an ACC or an Administrative Charging Committee within 1 year and 1 day after the date that the official employed by the agency became aware of the incident that led to the investigation. But if the alleged police officer misconduct is related to activity that reasonably appears to be the subject of a criminal investigation, an Administrative Charging Committee or a law enforcement agency must file any administrative charges within 1 year and 1 day after either the date that the investigating law enforcement agencies determine that the matter is not related to criminal activity, 2, the final disposition of all related criminal charges, or 3, the Administrative Charging Committee or law enforcement agency's receipt of notice that the appropriate prosecutorial authority declined to file criminal charges. There are no amendments in your voting packet.
I want to just jump on. Same, all right. Senator, I want to do the same thing. That's, yeah, so Senator James, Senator Smith. Yeah, I'm getting on too. Yeah, I'm getting on. It's Senator West wants to get on. Senator Wallstreicher wants to get on. All right. Senator Muse wants to be on.
All right, I have James, Smith, West, Waldstreicher, and Muse. Anybody else?
All right.
Okay.
Senator McKay.
Get down on it.
Yeah, James, Smith, West, Waldstreicher, Muse, and McKay.
All right. The motion is favorable with amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 533 passes unanimously with the amendment. All right, now move on to Senate Bill 540.
Senate Bill 540 prohibits a cooperative housing corporation, condominium association, or homeowners association from acquiring certain sensitive information from a member, owner, or occupant, or the guest or child of one of them as a condition for accessing or using a recreational common area such as a reading lounge, game room, playground, or swimming pool. Sensitive information is defined as an individual's Social Security card or number, taxpayer identification number, birth certificate, racial or ethnic origin, national origin, citizenship or immigration status, or religious or philosophical beliefs. Sensitive information does not include an individual's government-issued photo identification, such as a driver's license.
I just want to jump on as I'm going to jump on as a sponsor, co-sponsor. Yeah. Anyone
Anybody
else?
James,
Senator James is going to jump on?
Yes.
All right. Now the bill's before you as amended. Motions for favorable with the amendment.
second.
Is everyone okay being recorded in the affirmative? All right, Senate Bill 540 passes unanimously with the amendments. Now move on to the last two bills. Yes?
These are the last two bills?
It's 5-4 what?
Give me 1 second.
You want to be down or up? Okay. Yeah.
Hold on, give me 1 second.
62.
Yeah.
5, 4.
There's Baltimore City doesn't have.
540. What bill
So,
number?
so hold on one. All right, so Senate Bill 573 is on hold because we don't have a delegation letter yet, and Senate Bill 608 is on hold because we're still working some things out. So we have Senate Bill 545 is next.
Senate Bill 545 prohibits a person from violating specified prohibitions relating to the distribution or possession of child pornography with 100 or more images that are counted as specified under the bill. The bill also prohibits a person from violating those provisions with any image depicting a minor or an individual indistinguishable from an actual and identifiable child younger than age 13. Violators are guilty of a felony punishable by imprisonment for up to 10 years. Sentence imposed for a violation may be separate from and consecutive to or concurrent with any other sentence imposed by the court for any other crime based on the acts establishing those violations.
Senator West would like to be added as co-sponsor. Senator, I think I'll be on as well. So Senator James, Senator.
It's her bill.
Oh, sorry, yes,
right?
yes.
Okay.
Looks like
West,
Senator Folden,
Smith,
Senator Muse, Senator West,
Muse.
Wallstreicher, Smith, Henson, Love, McKay, Charles.
No favor.
Hold on.
Hold on. Senators, hold on 1 second.
1, 2, 3, 4, 5, 6, 7, 8, 9. I just want to just.
Oh, I got my dinner.
So I've got West, Smith, Bolden, Wallstreicher, Henson, Love, McKay, Charles. Senator Sindor, Charles. I'm just, you don't want to be on correct.
He's asking a question.
I'm sorry.
I think I may have answered my question. I mean, I just remember the conversations that we had last year about this and the number of images and all that stuff. I think I'm fine. Thank you.
Now move on. Senate Bill 545 with the amendments passes unanimously. We'll now move on to Senate Bill 548.
Senate Bill 548 establishes factors in statute for courts to consider in child custody cases. The court must articulate its findings on the factors in a written opinion. Just for reference, the factors in the bill are taken from Rule 9-204.1, which governs the creation of a parenting plan by the opposing parties. And it takes the factors that the parents are supposed to consider in coming up with a parenting plan and puts them in statute for the court to consider.
So we've got.
Wait. I need another piece of paper. I ran out of amendments.
Hold on. We got.
Chairman, I'm sorry, before we go on this, I'm sorry, hold on. I got a call from my wife, she's out of endurance, but I wanted to be a co-sponsor on that last bill.
Oh, yeah, okay.
You were.
Yeah,
On the
yeah,
last
I
one?
put you on. Yeah, I put you
Yeah,
on.
you
We
are.
put- Yeah, excellent. Okay.
So who wants to be a co-sponsor on Senate Bill 548?
It's Henson, Love, the entire committee, it looks like.
Is it the entire committee except for Senator Sindor does not?
Yeah, he's
So the whole committee, everybody
Yes.
wants to be on it.
Lottie-dottie and everybody, as Senator Benson would say. All right. All right, now the bills before you as amended. The motion for favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 548 passes unanimously. We are done for the evening.